Are you about to deal with your superannuation during your divorce? Well, today we're going to be talking about a new trend that's come out that Mum hates that we want to warn you about. Welcome, Mum.
Hello, Laura. Hate's a strong word, but I probably do hate it. Hello, everyone.
So we've decided today we need to do a Mum wants everyone to be aware of episode. We've done a few in the past and we have put noses out of joint by doing these episodes. But we've also got a lot of thank yous when we do these episodes as well. So we're going to go ahead and do it. And if you don't like it, you can send us an email. So let's get to our jingle and let's get started.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
So, Mum, the thing that you are really worried about, the trend that you're seeing is that people, when they go to deal with their property settlement, are treating their superannuation as a different asset type, and they are just making it even. So they both have the same amount of super. Is that right?
That's right. That's what a lot of people are doing.
And that is what you are not happy about.
I'm trying not to have a rant. But superannuation has been able to be divided in all states of Australia for years now, even for de facto in Western Australia. And the law is quite clear that superannuation is a type of property, right? But I keep hearing from people saying, oh, we're just going to equalise our super. So if you've got 30,000 and they've got 100,000, it's 20,000, 100 for the maths. It's 120 divided by 2, you get 60. You've got 30, they give you 30, they keep 60. And then this other person who's got the biggest goes on to continue to earn lots more money than you do and continues to grow their super into the future. But if you're on a lower income, will probably only grow your super by a little bit.
Let's unpack that. And I know you've got some cases that you want to share with people to let them know why. If anyone is listening today whose ex has suggested let's equalise our super so it's fair, in inverted commas, we're going to talk about some cases that you can share with your lawyer or with your ex to be like, but let's unpack it a little bit. So if you've been listening for a long time, you would know that property settlement is all put in, everything you own is put into the pool in a generalised sense and split based on contributions before, during and after and future needs.
Oh my goodness, Laura. Yes, you're doing very good. I wish some of the lawyers who are giving our listeners advice knew that much.
But realistically, there's all different reasons why you may end up with more of the property pool or less of the property pool based on a whole range of factors that we've talked about in many other episodes. But it's not everyone just splits it in half and walks away like some people think. So why all of a sudden, Mum, are people thinking that superannuation is dealt with differently? Why is that?
Well, if you tell me, we'll both know, because I don't know why. It's become like a buzzword. Equalise the super, and it's presented to clients as a normal thing. Oh, well, we'll just equalise your super because that's fair. And then we'll look at the property, the non-super property, and well, you've got more future needs and you're not well. And so you should have 70% based on those things, but you're only going to get 50% of the super. How does that work?
Yeah.
It works if you say, look, instead of getting 70% of the super, I'd rather have the cash. Well, that works. And one of the cases I'm going to talk about today, that Baxter Baxter, was just like that. But where the trial judge fell into error there with Baxter Baxter, they thought about contributions only. And I guess the golden message, embroidered this on a cushion, Laura, the golden message is that superannuation is property too, and all of the aspects about dividing property, including future needs and contributions and everything, applies to super as well. So the only people who would like super to be equalised is our mythical person with the $100,000 a year. They give the ex 80%, 70% of the property, but they keep up this. It's just not, it's not a thing, and we shouldn't be encouraging it.
So if you did the maths, if you were kids divvying out lollies at the tuck shop from school and you had that bag and you break it in half, but the toffees I don't know who eats toffees these days. I don't know. I got it, but the toffees, because they're not technically lollies, they're just going to be
50-50,
equal.
yeah.
Yeah. So doesn't seem to make sense to me that this is happening. And I think, Mum, as you mentioned, there are a lot of lawyers who just aren't educated in family law and they just think that's what's done, along with the myths of 50-50 child custody. Now there's this myth of 50-50 superannuation. So is it just uneducated or is it easier to do?
I think it's contagious. I think that younger lawyers are hearing other people talk about it, other senior lawyers talk about it. And I'm looking at you, Melbourne, and I'm looking at you, Sydney. It seems to be in Melbourne and Sydney that these buzzwords, sorry, you'll never hear anyone much say about it in Queensland because we know the law. We apply Section 75. We apply future needs to superannuation and to property. And my apologies to those people in Melbourne and Sydney who do know that this isn't right. But here's the thing. If someone came to me and I'm acting for a person, right, and that the other person has got 80% of great share of income, higher income, and they say to me, we'll equalise your client super-wise, so she gets that super, and she could have 80% of the property pool because, and they list off the factors. If that property pool percentage isn't much higher than you normally would get of the non-asset supers, if it's just the normal 5% for this and 10% for that, then you are really letting your client down by agreeing to equalising the super. So I want the one message I want everyone to take away from all of this is if your client uses those expressions, ask them how it fits in the whole property pool thing because it often isn't fair. It's just, I think, could be easier, Laura. But sometimes they say, each keep your own superannuation. And it might be that one person prefers more cash because they haven't got the higher income and they want to buy a house or something, which is similar. That's what happened in Baxter Baxter, ultimately in the Supreme Court. But future needs applies to superannuation assets as well. Just does.
And when we were talking about contributions, non-financial and financial, before, during, after marriage, as well as future needs, you can go and listen to those episodes. They are much earlier on, really bad quality, but they do exist. Or you can do our course and get our spreadsheets and figure it all out for yourself. And you can come out with a close percentage to maybe what you should be asking for. But I think we've left out an element here of reasons why people want to equalise super. And that's for the ones have been told, don't you touch my super. And so the next step up from I won't touch your super is, okay, maybe we'll just equalise the super. Is that the new way to placate the poopy bums that don't want to do what's actually fair?
I think if the equalising super is presented to an unscrupulous person, an unscrupulous poopy bum, as you would say, then they would rather have that than go to the court and find out what the court's really going to do. Do you know, Laura, we talk about financial and non-financial contributions before, during and after. That's your potted history. And then we talk about future needs. There is a little element in the Property Law Act, even now, that talks about a contribution as parent and homemaker, right? So for those people who stay at home. So sometimes people say, we don't split the super with the person who stayed at home because they made no contribution. Well, that's rubbish. They've made contribution if they've been keeping house and so forth. And then similarly, future needs to apply.
So it's really important, I think, as you're pointing out, that people know that it doesn't have to be financial. It can be parenting. Parenting's a big deal. And look, you don't get paid super while you're taking the kids to kindy or while you're doing Play-Doh. There's no one paying you super and there's no one paying your wage.
That's right.
And it's so unfair for people to say, that's my super, how dare you take it? I did all the hard work. When you're like, but you couldn't have done the hard work if you were at home playing Play-Doh with the kids and changing their nappies.
But do you know, it's not just that. And I think people should remember and emphasise their non-financial contribution in the form of parenting. And that is usually someone's in charge of the bills, someone's supervising renovations and repairs, someone does the Christmas shopping, birthday shopping, all of that. Someone keeps the house going, organises the pest controllers. There's a lot of load that a person staying home can take off a person trying to work. And it doesn't have to involve kids. And it doesn't even have to be a very long relationship. if you've got those changes, you're still working so that your ex can do the work, can get the pay.
And if
they weren't paying money into super during all of that time and instead put that money into a house, a block of land, no one would doubt that you're entitled to some of that block of land, even if it is in their name. And what's happening with super is you're foregoing the opportunity to spend the money now. And watch out, guys, for extra contribution and extra tax in terms of dodgy things to do. Some people will increase their solution and some lawyers won't notice it and they're siphoning it off. And then they say, oh, I've made a greater post-separation contribution to the super. But really, how have you done that? Have you reduced your income so that you don't pay child support because of that? What's the mechanism of that? Yeah. And another one is the tax. I always check and see what they say their wage is on a financial statement and what they say their tax is. And go and have a look at the tax scale and see, are they paying extra tax in so they get an extra refund at the end of the year? They do. They do.
You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your question. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today.
Let's go back to super for a minute. So these people some of our listeners may fall into the category of they just don't know and they're trusting their lawyer or their ex's lawyer to say that all you do is equalise super. Other people may be doing it because they feel guilty and they feel like they do it at all. So equalising is as good as they're going to get. And other people taking that option because they're too scared to not take that option.
Yep.
Mum, is it important to note that, and we did a great episode last week on emotional abuse, that potentially coercive control and family violence could play into how superannuation is split as well?
Well, it will, I think, because the changes to the law on the 3rd of June of this year, 2025, are going to allow the court to look at people's behaviour during the relationship in terms of property settlement. And as we all know, superannuation is property. It's treated as property. Sometimes you might make it two pools, like if there's been a massive extra contribution by someone to their super post-separation, but it still has to be treated as part of the property settlement, and all of the future needs factors, age, state of health, caring for the kids, apply when you're looking at super, as well as when you're looking at property settlement. And the only time I would like to hear equalisation of super is when you add it all together and look at it holistically, the person is getting the correct percentage of the overall property pool, not just the stuff that's not super.
So the equalisation of super happens by accident because that's how the percentage worked. It's not going to happen on purpose.
Not by accident, but the court has, at the end of their planning, at the end of looking at whether they should make an order at all, then the next step, what are the assets? And then the third step is looking at contributions, and the next step is looking at future needs. Their final step is to have another look at the split between superannuation and non-superannuation property and see if that is just and equitable overall. And it might be, as happened in Baxter's case, where the wife had a lower income. She was going to be unable to get as big a loan as her ex. She needed cash to get her on the property ladder. He, on the other hand, he wasn't left with as much cash, but he did keep a lot more of his super, but he could earn and save and buy something later on. That just and equitable is where it gets tweaked. And in Baxter, they just left it like it was because she needed more of the property pool. So they didn't tamper with the superannuation equalising so much, or each party keeping their own super so much as they gave her extra hard cash. And you need to know your ex. You know if they are crazy in love with their super, or if they go, meh, it's such a long way away. I don't need it.
And I think you've hit another nail on the head. The other one is where they say, we'll just leave super as it is and not even include it at all in the property pool. So that's just as bad. So the court has looked at and made rules for all of this to make it fair. And someone somewhere has started a rumour that equalising super is part of the process and that's part of the court system, and it's not. And people might go to mediation with lawyers that believe that.
Yes.
And then get a consent order and then walk off and then know that was a mistake.
Well, and they'll do it in tables. Oh, well, you'll get an extra 5% for lower income earning capacity and maybe an extra 10% because you're not well or whatever. So it's an extra 15%, and then they just apply it to non-super. So when you look at it overall, it's a much less percent than you should get. I have not heard of lawyers trying to say that super is not part of property. I think everyone understands that. But you know where you say the court's made these rules? The court has. But with Coughlin, it's a case in 2005 where the court taught us how to work with property and non-superannuation property, with super and non-superannuation property. And so that's your leading case. So I think that, but the court isn't the only one who's made the rules. The government has made the rules. The government legislated that superannuation was property and how that would work. They changed the Family Law Act to include that. And nothing's changed since that happened, 2004. But it's just been in the last couple of years that I've heard this equalising super.
So can you tell us some cases about a case that people can then tell their lawyer about, or their ex, if their ex or their lawyer is saying it's time to equalise super and we treat it differently to the property pool?
Yeah. So Coughlin, of course, it's Coghlan and Coughlin of 2005. That's the leading case, and your lawyer will know that case. A more recent case, it's 2010, it's still 15 years ago. It's called Baxter Baxter. And in that case, it was an appeal against a judge's decision where he failed, or she failed, to consider future needs when dividing up the superannuation. They just looked at it and said, the most contribution was from the ex, therefore we'll leave the super as it is, or whatever. So that's a more recent case where they've wrapped him over the knuckles. And it's clear. It's clear. The law is clear and nothing's been changed in the law. So it's just a bad habit.
Is there anything said by the appeal judges that stands out to you that you could read out to people now?
In the appeal, the grounds of appeal were included that the trial judge had failed to give sufficient weight to the wife's Section 75(2) factors, which favoured her. And so they weren't really just and equitable orders in terms of the wife. Even though ultimately the court left the super split as it was, they gave her an extra, I think, 20% of the other assets to compensate and make up for that switch. And I think it was really quite an error that he didn't look at Section 75(2) factors in relation to super. And that's the issue I'm seeing. People agree to equalisation of super. That's the first, we'll all agree to that. And then they don't look at giving extra part of the property settlement. And so in this case, they said because the husband had greater super and they're going to leave it like that she would get a bigger share of the non-superannuation property.
I'm going to put you on the spot here, Mark. And I've brought up the Family Law Act Section 75(2) factors.
Oh, yes.
And I think maybe we should quickly touch on them because people are listening to this, they may go, well, I don't know if that relates to me. So
okay.
I'm just going to read them out really quickly and you can tell us if that would relate to superannuation as well.
Yep.
So I think matters to be taken into consideration in relation to spousal maintenance. That's what it says. But
no, well, the current legislation, if you look at Section 79, which is where they talk about the contributions, they also talk about matters to be taken into account, including those matters in Section 75(2). So they're changing that. 3rd of June, the legislation's come through to repeat those things in the property settlement. Yeah. So, property settlement.
That's right. Lawyers getting caught up because they're not paying attention to these.
I don't know.
Oh, well, let's have a look. So matters to be taken into account are the age and state of health of each of the parties.
Yeah. So if one of you is older than the other, significantly older, 5 or 10 years older, then one of the things the court might think is you haven't got as long to work to accumulate super before you retire. And so you may get an uplift or an extra 5, 10, whatever % on account of that the other person's got a longer working life.
Okay.
If you're sick, state of health,
Yeah,
might get
true.
more. If you're too sick and you don't have long to live, it actually reduces your future needs. Carrot's case for that. Yeah.
Okay. The income, property, and financial resources of each party and the physical and mental capacity of each of them for appropriate gainful employment.
Yes. A bit of a mouthful, isn't it?
Basically, your income and your earning capacity.
Yep. It is. And also what you're getting, what you already own and what it is that you're going to get pursuant to the court orders. So in Baxter, he was getting a much greater share of the super and he had a high income. And so they gave the wife a lift in her share of the other assets because of that. So the court just looks at how well off you are. They kind of look 10 years down the track and see, if we just do this, if we just divide it on contributions, will they be all right? If they won't be all right, then we can look at each of these and see what factors come in. And there was a study done, and I hope now, like that it's probably 20 years ago, it was called the feminisation of poverty and I think it was one of the reasons they started to split super, because you couldn't split super and whoever owned it kept it. And even if the other person who didn't have the super got everything, there was very unsatisfactory because the person who got everything didn't have any future set aside for them. And the person who got nothing except their big fat super ended up unable to move out of mum's back bedroom.
Also mentions children,
yes,
whether they have to take care of kids
yep,
who are under 18.
Yep.
So that's considered for future needs.
Oh, it is. It is. And that's even if there's child support coming in, because you still have like other expenses in terms of your housing and so forth. During the 50-50 days of children sharing, I think this was the reason, unfortunately, that some people wanted 50-50, because then that just negated that percentage increase. Yeah.
Okay. Now, there are a whole bunch of other ones you can go. We actually go through it in detail in Spousal Maintenance, Are You Eligible episode, which ironically has nothing to do with superannuation, but like Mum said, it says to consider these factors. So I'm going to skip some of them because they're a little obscure. But there are where the parties have separated, divorce, and a standard of living that is in all circumstances is reasonable. What does that mean?
Well, the judges have struggled with that a little bit. They don't mean it has to be as good as it was before, right? It just means that it's good enough.
If you're living in a mansion and that doesn't mean you still get to live in a mansion.
No,
it just means you live in some sort of comfort.
Yes, that's right. And it's really important if you've got the kids as well. So it doesn't get argued very often because it's pretty hard to argue it black and white, what's reasonable. And we don't want to be spending our clients' money trying to get the court to tell us what is reasonable. Your gut knows. I had a lady once years ago, and she was living in converted ablutions block at a caravan park. And it had 3.
What's an ablutions block?
It had 3 toilets and a hand basin and a shower. And and that really wasn't considered a reasonable standard of living for her.
So, Mum, there is a whole list of things that need to be considered when it comes to superannuation and how to sort it all out. But the big message you want to get across is, really, I think it is, you're going to have to educate yourself.
Yeah.
Know what the rules are. And don't take it for granted that your lawyer knows, because I am horrified that there are lawyers out there saying this. And I don't know whether they're doing it because they want to get the most for their client or whether they actually believe that's a thing.
I had a young...
I just might let it go through, do they?
It depends. If it's fair, if it looks reasonably fair, but obviously not everyone agrees. And sometimes the judge makes a mistake, which is why the appeal court had to step in that case. I'm shocked. I did have a young lawyer argue with me about it, but I was very pleased to read a recent article, but I can't remember the name of the article. But yeah, it's just a nonsense. You have to treat super the same as you treated any other asset in terms of looking at future needs.
What did the article say?
The article was just saying that we're forgetting that Section 75(2), future needs factors, like age, state of health, and all of the things that you look at for property settlement applies to superannuation too. even if you treat it as a two-pool approach, like one pool is non-super, one pool is super, or if it's all together, because you can do it either way. That's what Norbus's case said. But there is this bad habit creeping in of not considering the person's future needs, age, state of health, and all the other things. So if your lawyer's saying to you, let's equalise the super, I think your smart answer should be yes, but only if I can get a satisfactory share of the existing property. And it won't be dollar for dollar. Like $100 super, when you're a 40-year-old, $100,000 in super compared to $100,000 in the bank today, there's a world of difference. You won't get that other super till 20, 30 years. So you would get maybe, I've seen a case just recently where they gave her $80,000 instead of the 100 that the strict interpretation would have given her.
Oh, okay.
Yeah, because she was getting it in cash instead of super.
So superannuation dollars do not equal the same as cash dollars?
No. That's long been understood by people. If I offered someone who wants to get started in their life, you can have $100,000 cash and that's all you get, or you have $100,000 super and that's all you get, you can see people would go for the cash. And with the cash, they could buy their own property now and it might grow in value going forward.
So maybe that's where the confusion's coming in.
It is.
Knowing that it's a different kind of amount of dollars. But I really cannot stress enough, if you haven't listened to our Pitfalls of Percent episode, we talk about how discussing what percentage you're going to get of the property pool before figuring out what the property pool is can be a massive pitfall. Can you just remind people why that is and important for this?
Yeah, well, it's important for this because in the don't touch my super, that's a decision you've made on percentages, really, whatever that percentage is. And if you say, we'll equalise the super, you've just made a percentage choice in relation to part of the pool. The reason we don't do percentages early on in the proceedings is it's very easy for people to say, sure, I agree, 50-50 or 60-40. But then what people do is they start to kind of load the dice, as it were. So anything that you're going to keep, the other person may say it's much more valuable than you think it is. And suddenly 60-40 means you're not getting what you thought 60-40 was. And it invites arguments about the values of different things. Well, if you're going to make me have $5,000 worth of piano in my 40%, what about your cars and tools in the shed? And you get into that. So you're better off actually arguing either in dollars or don't set a figure at all when it comes to an agreement. You may have to, in your applications to the court, wants more clarity. They want to know who gets what and what percentages it is. But when you're negotiating, locking in on a percentage just invites countless arguments. And so many people say, we've agreed, but, well, you haven't really agreed because, and then if you try to back out of that and say, no, this isn't working, I don't want to work on those percentages anymore, the other person can be disappointed and grumpy and feel you're acting in bad faith and not want to properly deal with you. It's just a dilemma, and I don't support arguing in percentages in the first instance. Why don't you say, we'll sell the house and we'll split that, whatever, you can do a percentage there, but then with your properties, with your money in the bank, you can put amount and make it clear what's what.
So until you know exactly what the whole pool is worth and you've agreed on it, starting to say percentages is a big boo-boo. Go listen to that episode because there's some great strategies there. And a lot of dirty tactics that they use where they'll say, oh, yes, let's agree to 50-50. And then they'll say, but this isn't part of it because this isn't worth anything. My car's only worth 10 grand when you thought it would be worth 100 grand. And all of a sudden, your 50-50 split may look like it's 10 cents.
Yes, and there's a reason. If you read enough judgments, you'll see in property matters, the judge never starts off by saying, I find that the wife should get 60%, the husband should get 40%, and then go through. They don't. They start off with the facts and then they apply the law piece by piece by piece. They work out an appropriate settlement kind of thing, and then they say, that is approximately X percent of the property pool. So they double check it with the percentages, but you don't say the percentages first and then try and work back because it just doesn't work. And what if you agree on a percentage and the super's not included? You're really in trouble in terms of negotiation.
So if anyone's thinking about seeing a lawyer about their super split, or their super and their property split, what kind of things should they be taking to the lawyer's mum? What information does a lawyer need to help make the decisions on this kind of stuff?
Okay, or to give you proper advice. Yeah, so they need like that chronology that we've got in the course, I think, isn't it, where you say your ages and dates of birth and so forth. You've got to go into who brought what into the property, who had what. If you had a house when you got together, what did you sell it for? How much was the mortgage? What did you have left? And what did you do with that money? So you can do a trail. These are for the contributions elements. You might want to take in evidence of what your superannuation was at the beginning of the relationship compared to how it is at the end. Depending on your case, you might have an indication of the other person's superannuation as well. And then how property is at the moment and whose name it's in. And then the court will want to know, so that gets contributions pretty well covered. And then they'd like to know about you going forward, your earning capacity compared with theirs, any things that he has done in the past or she has done, but to minimise their income, that might be important. And then, like you said, age, state of health, whether you've got the care of a child under the age of 18, is one of you getting a pension from the government? Do you have any pending personal injuries claims, inheritances from a will, all of those sort of things. So go through them in the list, look at section 79.4 and 75.2 and the corresponding section 90S, I think it is, for de factos. And Western Australia, you also have similar sections of the Act. And then you know what you've got to tell your lawyer.
Okay. All right. Now, Mum, I am going to ask another question for anyone who's listening, who's pulling their hair out the whole way through going, but I've got a defined benefit fund that I've got to deal with, or I've got a self-managed super fund. So I haven't dealt with differently when it comes to this?
Look, once you've got the valuation of them, then no. Okay? If you've got someone with a defined benefit fund and they are receiving a pension, the court may make an order splitting the pension with you, which means you get a superannuation interest of your own and a particular amount of money each week from that sort of mother load of stuff. That's if you're in the Defence Force. Self-managed super funds, they're super funds, and that's all they are, but they need to be compliant, and the court will want them to be made compliant before they will deal with them. But it might be that they can order the sale of this because it's self-managed and there's only the two of you usually involved. You can sell the asset, the underlying asset might be the house or whatever, and each of you have super rolled into your own super funds. But it's no different. You can demand, an order can be made to split any of those types of funds, not 50-50, but in a different way.
And one more question.
Yep.
And I know this probably sounds a stupid question, but some people do think, and I know we've talked about it the whole way through, but some people think that they can access their super after divorce. Like, when they take the money out and it's going to their line, they can grab a bit on the way past. Can you access your super?
No.
Wouldn't it be good, though, if you could use it for legal fees? Like, that would stop a lot of post-separation abuse.
Well, except the lawyers be happy, but you're diminishing the property pool for future. And it might be that if you can afford to keep fighting, you will keep fighting, when at some point it might be obviously sensible to stop fighting about things. So you can't pull a bit out as it goes past. That's why it's called rolled over. It goes straight from your self-managed super fund to whomever else you've got for your super fund. Some people, I think they can set up mirrors self-managed super funds, but I don't know anything about that. You need to talk to your accountant. Yes, so that's an interesting discussion, but there's not much difference in them.
So really, today's episode was a big mum rant to say, hey, are you equalising super? No. Go and see a lawyer. Make sure that it's right for you. Make sure you're doing the right thing. Make sure that even if you don't end up in court, even if you don't go to court, the law is the law and it still applies. That's how it's supposed to be applied. It's great that you don't end up in court. I saw a stat the other day, Mum, it is 3% end up in court. That's just 3%.
At the final hearing, yeah.
No, 3% end up sorting out their stuff in court. Yeah, it's through court. Yeah.
Yeah, wow.
So that means there's a lot of people out there who are going to mediation, negotiating, doing it themselves, which is amazing and fantastic because, heck, no one wants to go to court. But catch with that is you may end up, if you don't know what the law and the legislation is, may end up getting yourself not fair outcomes.
Yep.
Be careful.
I mean, Raz, if you do a consent order and put it into the court, the registrar will look at that and see if it's just and equitable. They can't make an order. They must not make an order unless it is fair. And they may reject the consent order and say, no, this doesn't look right, the percentages. Explain it to me again, it doesn't look right, and you may need to rethink. But what worries me is that financial agreements, the binding financial agreements they used to be, BFAs, you can put anything pretty well in those, not legal advice, general education only, but you're not getting the scrutiny of the court when you do those. And if you're being asked to do one, to agree to one, make sure you find a lawyer who gives you good, solid advice. And I would have to wonder why the other person doesn't want the court looking at the document as you go through. And I did have a lady say to me one day, not too long ago, that her lawyer said, do a BFA because consent orders have to go through the registrar and they might reject it and they just stuff it up.
Which means basically, if it stuffs up and you do a BFA, there's no undoing it. At least you can get it undone. Like if they say, oh, there's a big glaring mistake here.
Before they make the order. Yeah.
Mum, last question.
Okay.
If you could embroider something on a cushion for everybody to have on their couch about superannuation, what would it be?
Superannuation is property and should be divided based on contributions and future needs.
Okay. And on the flip side, something a little less legally?
Equalisation's not a thing, or at least it shouldn't be.
How very polite of you,
Yes.
Mum. I'm really impressed. I don't have to edit this one. Well, look, I know super is such a boring topic. I hope you haven't fallen asleep halfway through this, but even though it's boring, it is hecka important. And I think you really need to keep your finger on the pulse for super, because I know a lot of people with everything else going on, kids stuff or selling the house, the last thing you care about is your superannuation, particularly if you're nowhere near,
retirement.
So just don't let it slip by or go through to the keeper. Like, you really need to keep an eye on it.
And your future self, Rose, your future self will thank you, guys.
Yeah, that should be embroidered on.
That's a good one, yeah.
I would be a lot quicker to embroider. The other one would have taken me a while. All right. Thank you, Mum, for your time today. We'll
no
be
worries.
Back next week. And take care, everybody, and keep your super safe.
Bye, Laura. Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.